now that a lot of the legal cases are actually live, we're seeing the justices, talking to the lawyers, and it's out there in the open. One of the things that I have noticed, and actually a lot of people have been commenting about this aspect, is, we all respect the judges. After all, they are dispensing justice. But there seems to be, and I have felt this, that the judges, many of them, not all of them, demand subservience from the lawyers and also the litigants.
So according to me, this is definitely not a congenial atmosphere for the justice delivery to happen. So whenever you see the Supreme Court overstepping its jurisdiction, invariably it happens because there is nobody there to point out to them that, look here, this is not your domain. There is a concept of separation of power, which is a basic feature of our constitution, and you are getting into an executive domain exclusively, and which you should not. Now, if you look at the history of this court, whenever they have been asked to define what is the judiciary's power or the executive power, they've always done it correctly. It's only when they start hearing a PIL, or if they start, deciding something which is to do with the executive, they sway and nobody tells them. And I feel that this atmosphere of, expecting that kind of subservience from the lawyers is not correct at all, because it ultimately...
So you agree it does happen?
It does happen, and it is something very wrong for the institution, I feel.
So you talked about the Supreme Court taking in PIL cases and also taking suo motu action in a number of, and which is the prerogative of the Supreme Court. I have figures in front of me. Of course, I was going to come to those later, but I think this is the right time to talk about them. The Supreme Court has some 80,000 plus cases which are pending. We have a bench strength of 34 Supreme Court judges. I think we have 33 right now. How does the Supreme Court dispense justice to 80,000 plus pending cases?
So it's a twofold, I would say, problem as far as this disposal is concerned. Firstly, as you earlier pointed out about the PIL jurisdiction, a lot of the time the court is being taken up by the PIL jurisdiction. So the PIL jurisdiction is not the jurisdiction for which you were created. I'm not saying that you're not doing some of the PIL work that they've done is also exemplary. But the way it is being taken up at the cost of regular litigation piling up is not something which is acceptable. If tomorrow, supposing the executive were to say that since you are not able to decide these matters now, all the 5-year-old matters we'll decide, that will be a breach of separation of powers. But nevertheless, the executive will be justified that you are not able to decide it yourself. Like what they do for the executive, they say you are not deciding this, or you're not taking this difficult decision, so we'll take that decision. That is where the fallacy happens. Second is, of course, the I would say the lack of decisive judges. I mean, a lot of our judges are very good. You may be a brilliant judge, but if you're not decisive, you really doesn't keep the wheels of justice moving at the pace at which we expect it to do. I remember a long time back, I had appeared before Justice Irani in the National Consumer Forum. I was, I think, 1 or 2 years in practice, and it was an appeal. And when I stood up, he asked me to sit down. And he read the file, and he asked the other side, what's your answer? They didn't have an answer. And he started dictating the order, heard both sides at great length, and he dictated a full-fledged order. And it was a perfect order. So, not that it went in my favor, it could have gone against me also. So, what I feel that if the judge is, if he reads the brief comment and if he is decisive, disposal can be much faster. So, there is somewhere, I would say, the lack of the initiative to get the right people to the institution. And that is true for the High Courts and Supreme Court both. So you have to get people who are decisive and who are able to, take a call immediately rather than hear a matter for hours and days together. So there I feel the quality of judges, of course, needs a relook. And also the infrastructure many a times, especially when the government is the litigant, you will find government never files its replies on time, and they keep taking time, and even when the matter is finally called out, they are not well prepared. So that is the other part, where you will find government litigation mainly, and even some private litigants also, are still in the adjournment culture, and they feel that adjournment is a matter of right.
Hey everyone, thanks so much for watching this clip. As you know, we are taking a deep dive into some complex issues and decoding them for you. So don't forget to check out more content on our channel. And also, we'd love to hear back from you with your comments and your suggestions. So let's explore together.